Hi there! So, for this video, let's talk about marriage. Yun yung first part ng family code. And hopefully, matapos natin yung family code today para makapag-poly na tayo for next week. Alright. So, what is marriage? Marriage is a special contract of permanent union between a man and a woman for the purpose of establishing conjugal and married life. Marriage cannot be terminated by will because the law specifies the grounds when it may be severed or annulled. Kaya sabi nga nila, 'di ba, the parties to a marriage, sino? The husband, the wife, and the state. So tatlo yung parties dyan. It's not just the man and the woman who wants to be married, yung parties sa marriage na to. It's a contract, but it's a special contract involving these three parties. It is not a mere contract, but an inviolable social institution. Its nature, consequences, and incidents are governed by law and not subject to stipulation. And because marriage is an institution, its maintenance is something that the state is very interested in. It is a relation for life, and the parties cannot terminate it at any shorter period by virtue of any contract that they make. So, hindi pwedeng magpakasal ka and then mag-agree kayo na may mga sarili kayong terms dyan. Like for example, okay, let's get married. But after 10 years, terminated na yung marriage natin. It isn't like that. The reciprocal rights arising from this relation, so long as it continues, are such as the law determines from time to time and none other. So, rights and obligations between spouses. These rights and duties are not subject to a stipulation between the husband and wife. And though they may voluntarily agree to any change in their personal relations, the agreement will be void and shall have no legal effect. So, ito yung mga rights and obligations between spouses. To live together, to fix a family domicile, to support the family, to manage family life, and they have the reciprocal right to demand the performance of these obligations to each other, and they also have the right to exercise their respective professions, if any. So, yung last na right, hindi porket asawa mo pwede mo siyang pigilan sa kung anong gusto niyang career. For example, hindi pwedeng sabihin ni husband na, okay wife, ako na magiging breadwinner, and ako yung magiging sole source of income. Gusto ko, nandito ka lang sa bahay, maging housewife ka lang, alagaan mo lang yung mga kabataan. So, hindi pwedeng ipilit ni husband yun kay wife. Vice versa. Hindi pwedeng sabihin ni wife na, okay, since I'm earning a lot and I'm earning more than you, gusto ko houseband ka na lang. Kahit na nagpakasal na yung man and woman, they each retain their individual rights. And one of the rights is, of course, to exercise their profession or to do whatever they want in their lives as long as hindi siya contrary to law, public morals, public order, customs, etc. Yung mga ganon. So, meron pa ring rights na individual. However, nadagdagan lang yung obligations nila since kasado na sila, and nagkaroon lang ng right yung partner nila na mag-demand sa spouse nila na ma-perform yung mga marital obligations na to. But maraming cases yan Right to privacy mo, nare-retain mo yan. Mali na sabihin na you become one when you're married. No. The man and the woman, even though they're married, they still retain their individuality, their right to certain properties, their right to manage their affairs, diba? Their freedoms and their right to privacy. So hindi pwedeng dahil mag-asawa na kayo, wala ng privacy. Kasi there is that case wherein the wife looked through the stuff of the husband. So the husband filed a case against the wife, and that case actually prospered. So, intrinsic validity of marriage as a contract. It is controlled by the parties' personal laws, whether domiciliary or nationality law. Intrinsic requirements include legal capacity of the contracting parties, and that the consent was freely given in the presence of a solemnizing officer. So, yung intrinsic validity of marriage as a contract, ito yung essential requisites of marriage. So, for the marriage to be valid, to be intrinsically valid, dapat present yung essential requisites of marriage. So, what are the essential requisites of marriage? First, legal capacity of parties who must be male and female. So, taken into the context of age, sex, legal impediments to marry, and other circumstances. A person's sex is an essential factor in marriage and family relations. It is part of a person's legal capacity and civil status kasi currently, clear yung family code natin that marriage is a permanent union between a man and a woman. In this connection, sex is defined as the sum of peculiarities of structure and function that distinguish a male from a female. And that sex of a person is determined at birth, visually done by the birth attendant by examining the genitals of the infant. The words male and female in everyday understanding do not include persons who have undergone sex reassignment. Furthermore, considering that there is no law legally recognizing sex reassignment, the determination of a person's sex is made at the time of his or her birth, if not attended by error, is immutable. Kasi there are times kasi nagkakamali sa pagre-register ng sex sa birth certificate. So, yung mga ganon, pwede yung i-correct. If, for example, female yung nakalagay, tas male ka naman talaga, diba? Unquestionably male and male since birth. So, yun yung biological sex mo talaga. So, pwede mong ipakorrect yun. However, for example, being a transgender man or transgender woman is not a way to circumvent the law that you cannot that marriage is only between a man and a woman. So even if you've undergone sex reassignment, even if your genitalia is now that, for example, if you are female, that your genitalia is now of a male, for all intents and purposes of the law, you are still female. So, whatever your sex is at birth, yun. Except, there is this case wherein there's an intersex. Intersex are people who are born with both genitalia and have both the features of a male and a female reproductive system. So, in this case, that person, I think it was Jeff Kagandahan, was given the choice to elect what sex to him is, pinili niya yata yung pagiging male, is more appropriate. Okay. So, consent, second essential requisite. Consent must be freely given by the parties before a solemnizing officer. A freely given consent must be willingly and deliberately entered into marriage without vices of consent. Okay, hindi tayo pala ako dito. So, what are the vices of consent? If it's attended by fraud, by force, by intimidation, or undue influence, then that is a vitiated consent or a consent attended by vice. Consent must be intelligent, with the parties fully understanding the consequences of entering into marriage. So, yung intelligent, it isn't yung IQ, but the full comprehension and understanding of the marital obligations and the impact of entering into a marriage, the knowing fully well the consequences. The parties should know fully well what they're getting into by being married. Simulated marriage is not valid because there is no consent here to be married. Absence of essential requisites of marriage renders, of course, the marriage void because it's not intrinsically valid. And any defect or irregularity renders the marriage voidable. So, pag absence of essential requisite, void. Pag may defect or irregularity but not absence, then it's voidable. It's valid until it is declared void. However, if there's absence, it's really void from the very beginning, meaning it's void ab initio. There was no point in time in a marriage void ab initio that the marriage was legal. It's void from the very beginning. So all the effects of the marriage will be rendered void. Of course, pinag-usapan na natin yung doctrine of operative fact. So, iba naman yan. But, yun yung, as in, reset. As in, wala. Parang you've never been married. Yung voidable naman, it was valid at some point until hindi na. So, consent refers to consent of contracting parties, not the consent of the parents, not the consent of the solemnizing officers, but the consent of the man and the woman entering into the marriage. Yung consent nila is what matters. The consent must refer to the contracting party's bona fide intention to be married to the other. If either party was of unsound mind or is insane, then consent is situated or defective and the marriage is voidable. Kasi there's defect. There's walang absence but there's defect in the capacity. If there is a mistake to the identity of the party, then the consent is totally absent. Therefore, pag absence, it's void ab initio. If there is a mistake as to legal consequences and nature of the marriage ceremony, the consent is absent. And if absent, marriage is void. If consent was obtained by fraud, force, intimidation, or undue influence, hindi siya absent, pero attended by vice, so it's defective and it's irregular. Therefore, it is voidable. Kasi pwede mo siyang later i-ratify. Na, for example, sure, at the time of the marriage, your consent was obtained by fraud. But later, you fell in love with a person. So, you ratified it. It's valid until it's voided. Sure, it's voidable, but then it's valid and you want it to remain valid. So, it's valid. Kasi hindi siya na-render na void. Okay, excuse me. Excuse me. Okay, sorry. Okay, next. If the marriage entered into by a person whose real intent is to avoid prosecution for rape, then consent here is absent and the marriage is void. A marriage contracted by any person during the subsistence of a previous valid marriage is walang legal capacity, absence. It's null and void. Unless, of course, may declaration of presumptive death if it's a case of presumptive death of an absentee spouse, which is a different matter, which we will discuss later. Okay, let's go to the extrinsic validity of marriage as a contract. So, it is governed by the principle lex loci celebrationis, and it covers the formal requisites of marriage under Philippine law. So, na-discuss na natin yung principle ng lex loci celebrationis sa previous video. All states recognize as valid those marriages celebrated in foreign countries if they comply with the formalities prescribed where the marriage was celebrated. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they were executed, including marriage. All marriages solemnized outside the Philippines in accordance with the laws in force in the country where they were solemnized, and valid there as such, shall also be valid in this country, except for same-sex marriages, or marriage with a minor involved, or bigamous or polygamous marriages, and other marriages that are void in the Philippines by reason of law, customs, and public policy and morals. So, yung intrinsic validity of marriage, yung mga formal requisites of marriage. So, these are the authority of the solemnizing officer, marriage license, and marriage ceremony. So, any absence of formal requisites of marriage renders the marriage void. Okay? Void rin pag absence. Kasi, for marriage to be valid, it must be intrinsically valid, which is yung substance, and then extrinsically valid as well as to the form. Any defect or irregularity, however, unlike sa essential requisites, defect or irregularity has no effect on the marriage kapag formal requisites. Ulitin natin Pag essential requisites, pag absence ng essential requisites. So, ano yung essential requisites ulit natin? Legal capacity. So, andyan yung age, andyan yung sex. Next is consent freely given by the parties before a solemnizing officer. So, yung consent, okay, yun. So, kapag present yon, yung consent and yung legal capacity, valid yung marriage. Kapag may absence, kapag walang consent, or kapag walang legal capacity, void ang marriage. Void ab initio. Kapag may defect or irregularity, voidable. Kapag naman formal requisites, ano yung formal requisites? Authority of the solemnizing officer, marriage license, marriage ceremony. Pag absent, okay, pag absent, void. Hindi voidable, void. Kapag may defect or irregularity, hindi voidable, walang effect. But it makes the party responsible for such irregularity civilly, criminally, and or administratively liable. So, sino yung mga solemnizing officers of marriage? Number 1, any incumbent member of the judiciaries or your judges or justices within their court's jurisdiction. Note that their authority to solemnize marriages are only within their territorial jurisdiction. So, if it exceeds sila sa territorial jurisdiction nila, there is, absence. Hindi siya defect, absence siya. No authority, absence. So, it renders the marriage void. Justices of the Supreme Court and Court of Appeals have jurisdiction to solemnize a marriage anywhere in the Philippines. A lower court judge can only solemnize marriage within their jurisdiction. A marriage may be solemnized outside of the judge's chambers only if it is in articulo mortis, or if it is in a remote place, or upon written request by the parties. However, the place must still be within the territorial jurisdiction of the judge. So, kung gusto nyong magpakasal sa resort at lumapit kayo sa Regional Trial Court ng Quezon City, then yung resort dapat within sa Quezon City. Hindi pwede na yung resort nasa Cebu and yung authority ng judge is hanggang Quezon City lang. Next is any priest, rabbi, imam, or minister of a church. So, kasama yung mga pastor dyan. In a religious sect, duly authorized by the latter or the religious sect. So, dapat, yung authority, yung pare or yung pastor or yung minister, dapat authorized by their church or kung ano man yung corresponding term nila sa church to solemnize marriages. Next is any ship captain or airplane chief for marriages between passengers or crew members during, at sea or flight, and stopovers in articulo mortis. So, si ship captain, si airplane chief, yung jurisdiction nila between passengers or between passengers and crew members or between crew members. And dapat nasa sea or flight, okay, nasa voyage, or nasa stopover, and dapat at the point of death. So, kung hindi siya at the point of death, walang authority. Kung wala siya sa voyage, walang authority. Kung hindi rin siya sa stopover, walang authority. Kung hindi siya between passengers or between passengers and crew member, between a passenger and a crew member or between crew members, wala rin siyang authority. Any military commander of the unit to which a chaplain is assigned, but only between persons, either military man or civilians, within the military zone. So, unang requirement, dapat may chaplain. Pangalawang requirement, dapat within the military zone. Consul General, consuls, and vice consuls in the country they are assigned, so outside the Philippines, between, so ito lang yung pwedeng ikasal, between Filipino citizens abroad. And lastly, mayor within his jurisdiction. The vice mayor can solemnize if he is the acting mayor at that time. Hindi pwede si vice mayor kung available naman si mayor at hindi siya yung quote-unquote acting mayor at that time. So, good faith of the parties, does it matter? Even if the solemnizing officer is without authority to officiate the marriage, if the marrying parties believed in good faith that such officer had authority, the marriage may still be valid. So, it's kind of like Chong, no? Mistake of fact. Kasi, sa circumstances surrounding the case, a person, a reasonable person, would naturally believe in that situation that the solemnizing officer had authority. Mistake of law is not permissible and it is not considered a case of in good faith if merong parang negligence din sa part ng contracting parties. Hindi mo masasabing good faith siya. Because ignorance of the law excuses no one. Hindi rin pwedeng mistake of law na si Gov yung nagkasal sa kanila. Kasi si Gov, wala siyang authority to solemnize a marriage. Akala mo mas mataas si governor kaysa kay mayor. Si mayor nga pwede, si Gov hindi. Hindi pwede. Okay? Kahit di mo alam yan, ignorance of the law excuses no one. So, you cannot invoke na, oh, we were in good faith. We really thought Gov had authority. No. So, marriage license. The license required is that which is issued by the local registrar of the city or municipality where either contracting party habitually resides. Di kailangan domicile. The publication is required. The civil registrar must determine the age of the parties. May typo lang ako. It is valid anywhere in the Philippines regardless of where it was obtained. So you obtain it where either of, if you want to get married, you and your partner can obtain it where either of you habitually resides. And then you can marry anywhere in the country. Doesn't have to be where you obtained the license. It is valid only for up to 120 days from its issuance, and it is automatically cancelled upon expiration if unused. The absence of the marriage license will render the marriage void. However, its mere irregularity will not affect the marriage and will not be rendered void. Irregularity will not affect the marriage. So, ano ba yung irregularity? Meron kayong marriage license pero hindi sa place where you both habitually reside. Okay? But unexpired marriage license is not a valid license at all. So, that is a void marriage. If the marriage license is simulated or not authentic, then that is absence, then the marriage is void. The local civil registrar is the official custodian of the marriage license, and the certification issued by such office must be secured as to the existence or absence of the marriage license. Without the fault of the spouses, it's not proof that there is absence of the marriage license. The local civil registrar must categorically state that after diligent search, there is no marriage license found, otherwise the marriage is presumed valid and shall subsist. So, kunwari hindi na mahanap kung may marriage license, hindi pwedeng sabihin na wala kaming marriage license so magpapaanal na kami. Kung walang statement from the local civil registrar na after a diligent search, hindi talaga namin mahanap. The duplication of marriage license numbers is not proof that there is an absence of the marriage license. The presumption of the regularity of the marriage prevails. If the lack of marriage license is apparent on the face of the marriage contract itself, it is not necessary for the local civil registrar to certify the lack of marriage license, and therefore the marriage is void for lack of marriage license. So, certificate of compliance. It is a document issued for free by the local family planning office certifying that the couple had duly received adequate instructions and information on responsible parenthood, family planning, breastfeeding, yun yung mga topics nila doon, infant nutrition, and ito, hindi na ito basta-basta certificate of compliance. This is required for a marriage license to be issued. No marriage license will be issued if hindi na present yung certificate na to, kasi ibig sabihin, hindi nyo kinumplete yung parang program. So, exempt from marriage license. Bakit importante pala to yung certificate of compliance na to? Kasi para alam mo yung pinapasok mo. Kasi nga, di ba, your consent must be intelligently made. And therefore, for the government or for the state to ensure that you really know what you're getting into, then you have to undergo this training provided by the government for free. So, to increase your awareness and for you to really know what marriage is, or what a married life is, or what having a family is like. So, the following are not required to secure a marriage license in order to marry. So, sino? If the marriage is in articulo mortis and, hindi na nila kailangan if it's at the point of death. Even if the ailing party subsequently survives. Same sa kapag solemnizing officer, kapag articulo mortis, sino? Kunwari, airplane chief or captain, ship captain. 'Di ba, at the point of death, sila, alam naman mag-secure pa sila ng marriage license. So, bakit ba nagpapakasal yung mga tao at the point of death? It's because, sure, yung iba for romantic reasons. Another is for practical reasons, for purposes of succession. Kasi, syempre, gusto mong bumuti yung buhay ng partner mo. 'Di ba? Mga ganyan. So, maraming considerations yan. So, kahit na mabuhay pa, when dying at that point, valid pa rin yung marriage nila. Hindi mo pwedeng sabihin na ay void kasi hindi naman siya namatay. No. Basta importante, sa time na celebrate yung marriage, dying yung isa sa kanila. Marriages in remote and inaccessible places. This is really true dito sa Philippines kasi hindi pa naman lahat ng areas developed eh. So, there are areas here that are really remote. So, it means, what do we mean by remote place? Restrictive or no means of transportation. In reality, there are places here that you can't go there. If not, masasakay ka ng bangka. If not, aakit ka ng bundok, mga ganyan. Marriages among Muslims and ethnic cultural communities, wala ng marriage license kasi iba naman yung sa kanila. Okay? Marriages between parties who have cohabited or lived together as husband and wife for at least 5 years. And marriages solemnized outside the Philippines where such license is not a requirement. Kasi sinusunod mo yung forms and solemnities where the marriage will be celebrated. So, yung tungkol naman sa marriages between parties who have cohabited or lived together as husband and wife for at least 5 years, mag-i-issue sila ng affidavit. So, a false affidavit of having lived together for 5 years as husband and wife cannot be considered as a mere irregularity. No. but a complete absence, rendering the marriage void ab initio. So, yung requisites para para ma-exempt kayo sa marriage license. So, the man and woman must have been living together as husband and wife. So, nagli-live-in sila. Hindi pwedeng hindi. For at least 5 years before the marriage. And the parties do not have a legal impediment to marry each other. Hindi mo, kapag meron ka ng asawa pala, tapos kinakasama mo yung kabit mo, isa kayong bahay, 5 years na or 10 years na, wala pa ring legal capacity yung may asawa. Kasi yung next yung anong marriage is gonna be a bigamous marriage for sure, which is a void marriage. So, hindi pwede. Dapat walang legal impediment. Or, yung kinakasama mo, minor. O, diba? So, hindi pwede yon. Kailangan may legal capacity yung both parties. The fact of absence of legal impediment between the parties must be present at the time of marriage, and the parties must execute an affidavit stating that they have lived together for at least 5 years and are without legal impediment to marry each other, and the solemnizing officer must execute a sworn statement that he had ascertained the qualifications of the parties and that he did not find, okay, mamali lang ako dito, and that he did not find any, he did not find any legal impediment to their marriage. Okay. So, yung sa abroad naman, there must be no legal impediment beginning the time of cohabitation, and there must be, dito sa abroad. Oh, may angulo ng notes ka. Okay. Wag muna tayo sa abroad. Tapos na yung abroad. Nasabi ko na yan eh. Sa ano pa rin tayo? Yung 5 years. Right? Ang gulo naman yan. Yan. There must be no legal impediment at the beginning of the time of the cohabitation. So, hindi pwedeng yung buong 5 years nyo na yun lang yung point. Pwede naman yung beginning nyo merong impediment. Pero kunwari 10 years kayo nagsama, first 5 years merong impediment. Sa latter 5 years wala nang impediment. So pasok na kayo kasi 5 years na kayong nagli-live together as husband and wife without legal impediment. So dapat at least 5 years na magkasama kayo na walang legal impediment. There must be continuity and exclusivity in the cohabitation. So 5 continuous years yon. In the cohabitation, and the parties must issue an affidavit of their circumstances, and falsifying affidavits will render the marriage void. The solemnizing officer must issue an affidavit of the circumstances of the exemption. Okay, let's go naman to marriage ceremony. It takes place upon appearance of the contracting parties before a solemnizing officer na may authority, wherein they each make a personal declaration. So, hindi pwedeng meron siyang, proxy. Dapat sila mismo mag-declare that they take each other as husband and wife in the presence of at least 2 witnesses of legal age. So, hindi pwedeng kayo lang. Hindi mo pwedeng gawing witness din si solemnizing officer. Solemnizing officer plus 2. Okay? Hindi pwedeng ando naman si solemnizing officer at yung assistant. So, no prescribed form for the ceremony and proxy marriages are, of course, void. Okay, so lex loci celebrationis, pero hindi natin discuss yung principle kasi hindi lang naman ito nag-a-apply sa marriage. Pero lex loci celebrationis in the context of marriage. So, yung basis natin dito sa Article 26 of the Family Code that states a marriage solemnized outside of the Philippines are valid there, and valid there as such is also valid in the Philippines with exceptions provided by law. So, if the parties have no legal capacity, or they did not give their consent, or if the marriage is bigamous, polygamous, incestuous, or violative of public policy, the rule will not apply and the marriage will not be recognized in the Philippines. This applies to mixed marriages as well. Proxy marriages, when permitted by law, of the place where such marriage was held is recognized in the country, adhering to the lex loci celebrationis rule, at least insofar as validity, insofar as formal validity is concerned. So, valid siya. Is valid. Ano ba yan? Okay. So, kasi form pag form, sure, bawal sa atin yung proxy marriages dito, pag dito sa Pilipinas. Pero kung doon, pwede naman, 'di ba? Then, okay. Kung legal doon. Common law marriages, even if valid, however, in the state where the parties cohabited while holding themselves out as man and wife, is not recognized in the Philippines. If the parties, or at least the husband, is a Muslim, it is believed that the Philippine recognizes up to 4. Hindi unlimited. Up to 4 lang yung inire-recognize dito sa Pilipinas. 4 marriages of the same husband is recognized by the Philippine Muslim Code on Personal Laws. So, hindi, as long as may pera ka, okay, kahit 12 wives pa yan, no. Dito sa Philippines, up to 4 lang. Kung meron ka pang extra, bahala ka sa buhay mo, basta yung ititreat ng law is up to 4 lang. Or i-recognize ng law is 4 lang. Personal law, the law which attaches to a person wherever he may go. Okay? So, for example, Pinoy ka, Filipino citizen. So, wherever you go, Philippine laws that apply to Filipino citizens shall apply to you. And generally governs his status, capacity, condition, family relations, and the consequences of his actions. Okay? The personal law of an individual is his, of course, as mentioned, national law. Nationality principle, Philippine laws regarding civil status applies to Filipino citizens even outside the country. Divorce, however, if validly obtained outside of the country, regardless of who initiated it, this is very important. Kasi, back when I was I was taking persons in law school, persons and family relations, dapat yung divorce para ma-recognize dito sa Philippines dapat initiated by the alien spouse, kasi daw yung logic nun is since nationality principle nga, the Filipino doesn't have the capacity to divorce, so kapag siya nag-initiate nun, hindi pwede, hindi ma-recognize. Pero kapag naman daw si foreign spouse nag-recognize, parang yun yung effect or something, so ma-recognize. Pero ngayon, 'di ba? It's recent Supreme Court decisions. Realize that it's ridiculous and it's unfair to Filipino women. It's causing injustice. Kasi imagine your alien spouse is a free man. Tapos ikaw, you're not. Like, bound ka pa rin doon. It creates awkward situations and absurd situations So, now the rule is regardless who initiated it, it is valid and recognized here in the country. Because blind adherence to this principle is disallowed if it results to injustice according to recent jurisprudence. So, domiciliary theory, also known as territorial theory, states that the status and capacity of a person is determined by the law of his domicile. So, it's just a theory. It applies in certain cases, it doesn't apply to certain cases. Some cases, the nationality principle applies. Some cases, the domiciliary theory applies. Mga ganyan. Situs theory, also known as eclectic theory, which states that the particular place or situs of an event or transaction is generally the controlling law, so it's kind of consistent with lex loci celebrationis. Theory of effective nationality. A person having more than one nationality shall be treated as if he had only one insofar as a third state is concerned. Without prejudice to the application of its law in personal matters and of any conventions in force, a third state shall apply the nationalities which any such person possesses, recognized exclusively in its territory, either the nationality of the country in which he is habitually and principally a resident, or the nationality of the country with which, in the circumstances, he appears to be in fact mostly connected. Judicial recognition of foreign judgment. Mere presentation of the decree before the trial court is insufficient. a separate action for recognition following procedures and requirements set forth by our rules of court and other related procedural laws must be filed by the parties for the courts to take judicial notice. So yung pinaka-common example, if you want your divorce to be recognized here, you have to seek for judicial recognition. Hindi pwedeng mag-act ka lang as single or ipakorek mo lang, di ba? Hindi pwedeng ganon. Dapat merong proper process na i-undergo ka so that you get that judicial recognition, so that the court takes judicial notice of your divorce. Okay? Or ano pa yan, kung ano mang foreign judgment yan. Like, for example, there's a decided case there. So, you have to present. Example rin is if you're alleging something, you have to present the foreign law. So, na-discuss na natin last video yung judicial notice. While the law requires the entry of the divorce decree in the civil registry, the law and the submission of the decree by themselves do not ipso facto authorize the decree's registration. The law should be read in relation with the requirement of a judicial recognition of the foreign judgment before it can be given res judicata effect. A petition for recognition of foreign judgment is a special proceeding which seeks to establish a status, a right, or a particular fact. So more on this on remedial law. And not a civil action which is for the enforcement or protection of a right or the prevention or redress of a wrong. So correction of entry. Article 412 of the Civil Code declares that no entry in a civil register shall be changed or corrected without judicial order. The Rules of Court supplements Article 412 by specifically providing for a special remedial proceeding by which entries in the civil registry may be judicially cancelled or corrected, and the ruling should not be construed as requiring two separate proceedings for the registration of a foreign divorce decree in the civil registry, one for recognition of the foreign decree and another specifically for cancellation of the entry under Rule 108 of the Rules of Court. So, yan. Rules on divorce in the Philippines. There's no divorce in the Philippines. What we have is relative divorce, which we call legal separation. Okay? Except if, we recognize the divorce that was obtained abroad, where marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad, capacitating the alien spouse to remarry, and the Filipino spouse shall likewise have the capacity to remarry under Philippine law. Or there's a valid divorce obtained abroad between foreigners whose national laws allow divorce. Okay. So if the non-recognition of divorce will work injustice and unfairness to Philippine nationals. So, ulit tayo, sinabi natin ito before. Pero emphasis, yes. The same may be given limited recognition in our jurisdiction. A divorce abroad is considered valid in the Philippines even if it is, again, the Filipino spouse who initiates or files for divorce abroad. So, let's go to void marriages. So, void marriages. The basis is Article 35 to 38 of the Family Code. Pag void yung marriage, it is null and without effect from the very beginning, making all consequences of such marriage without effect. Therefore, it cannot be rectified. It cannot be ratified. Rectified, hindi mo pwedeng i-correct. Ratified, hindi mo siya pwedeng i-accept you can't accede to it, diba? There is an absence of essential and or formal requisites of marriage. So, pag may absence sa essential requisites, void. Pag may absence sa formal requisites, void. Pag marami, void. Pag maraming essential requisites, void, na absent. Pag maraming absent na formal requisites, void. Pag combination ng essential and formal requisites na absent, void. It just takes one absence of either essential or formal requisites to make the marriage void. If there's multiple, then all the more. Same effect. The following grounds for void marriage may be raised at any time, meaning it does not prescribe. And such action that may be filed by other parties, again, of course, shall not prescribe. Meaning, pwede mo i-file at anytime, walang hanggang 5 years lang from the celebration of marriage. Wala. Anytime. Pwede mo siyang i-file. Bakit anytime? Bakit it doesn't prescribe? Kasi it's void from the very beginning and you just need a judicial declaration as proof na void talaga siya. To make it clear na void talaga siya from the very beginning. So, ano yung grounds? Minority. If the parties are below the age of 18 at the time of the marriage. Or lack of authority of the solemnizing officer. That's an absence. Okay? So, minority, absence of capacity. Absence to give consent. A lack of authority of the solemnizing officer. An absence of a formal requisite. Lack of marriage license. An absence of a formal requisite. Bigamous or polygamous marriage not falling under Article 41. The basis is Article 41. If there is a declaration of presumptive death, okay, yun yung exception. So, lahat ng bigamous or polygamous marriage, okay, void except, okay, may exceptions. Siyempre, pag Muslim, di ba? Up to 4 sila, yung sinabi ko kanina. Tapos, kapag may declaration of presumptive death, so meron niyang valid na subsequent marriage. Kasi sa general rule, 4 years of continuous absence, kapag ordinary absence, or 2 years of, na-discuss na natin ito sa previous video 2 years for special circumstances wherein there is danger of death or yun yung sinasabi natin extraordinary or qualified absence, di ba? The spouse of the absentee can remarry. In case the absent spouse reappears, so naging dalawa na, di ba? Kasal pa rin siya, magre-resume. Paano na yung second marriage niya, di ba? The subsequent marriage is considered bigamous, but it is valid and shall not make parties criminally liable. So, paano magiging valid yung bigamous marriage? Spouse made an active, diligent, and reasonable effort to search for the absent spouse. Pero hindi talaga mahanap. His or her whereabouts are really unknown. And the spouse had well-founded belief that the absent spouse probably died. Kaya, nag-seek siya or nag-obtain siya ng judicial declaration or presumptive death of the absent spouse. So, dapat merong judicial declaration of presumptive death. Hindi pwedeng i-assume lang, patay na yun siguro. Kailangan makasecure ng decree sa court ng judicial declaration of presumptive death bago siya pakasal ulit for the second time. Now, that is an exception. That is bigamous, but that is valid. Diba? In case na buhay pala. Yung iba, hindi pwede. Unless, of course, Muslim. Diba? So, sa case na yung Article 41, yung may absentee, the valid bigamous marriage will automatically be terminated upon the recording of the affidavit of reappearance of the absent spouse. At the instance of any interested person, with due notice to the parties of the subsequent marriage and without prejudice to the fact of reappearance being judicially disputed. This automatic termination shall not apply if there is a judicial declaration annulling the first marriage. An annulment of judgment is the proper remedy if a judicial declaration of presumptive death is erroneous. Mere reappearance of the absentee is not sufficient. So, kailangan may affidavit of reappearance. Kung wala, by fiction of law, meron kang 2 valid marriages. Okay? And dahil valid yung marriage mo na yon, the children of the valid subsequent marriage are legitimate. Okay? Kahit na may record pa ng affidavit of reappearance. The property regime of the valid subsequent marriage will be dissolved and liquidated after the recording of the affidavit of reappearance without prejudice to the forfeiture of the share of the spouse in bad faith in the net profits of the profit regime. Such forfeiture shall be in favor of the children and in the absence of the latter, the innocent spouse. Donations by reason of marriage shall remain valid except if the donee is the one in bad faith and then the donations are revoked by operation of law. The innocent spouse may revoke an insurance policy the status of the guilty spouse as the former beneficiary. The guilty spouse is disqualified to inherit from the innocent spouse, intestate and intestate succession. Pero as a general rule, kung hindi ka naman pasok dito sa absentee na to, kung wala ka namang declaration of presumptive death, a bigamous or polygamous marriage is void. Okay? Wala kang legal capacity. Next is incestuous marriages. So, void by reason of public policy. Okay, guys. So, paano ba incestuous? Kadugo mo, your ascendant or descendant, diba? Ascendant and descendant sila, pero nagpakasal sila, that's void. Or siblings, Whether full blood pa yan or half blood, diba? Pag stepsister mo naman, anong mangyayari pag step, diba? So, kung incestuous involving blood, pero meron namang void by reason of public policy na kahit hindi by blood, void pa rin kahit wala silang blood relations. Example, sinabi ko, between step-parents and step-children. Okay? Included din yan kapag step-siblings kayo. Okay? I think, tama ba? Between step-parents and step-children. Okay, let's put a pin on that. Between step-parents and step-children, bawal. Parents-in-law and children-in-law, bawal. Adopting parent and adopting child, bawal. Surviving spouse of the adopting parent, okay? Yung asawa ni adopting parent. Syempre, kung kasal pa sila ni adopting parent, bigamous. Kasal siya, wala siyang legal capacity. Pero kung kunwari na naging widow, 'di ba? Pwede na mag-remarry yung asawa ni adopting parent. Tapos pinakasal niya sa adopted child, hindi pa rin pwede. Surviving spouse of the adopted child and the adopter, hindi pa rin pwede. An adopted child and the legitimate child of the adopter, bawal. Kahit wala silang blood relations kasi parehas silang parang legitimate child. Hindi parang, legitimate child talaga yung treatment sa kanila, sa adopted. Adopted children of the same adopter, kahit hindi sila magkakadugo. Okay, parties were one with the intention to marry the other killed that other person's spouse or his or her own spouse. So, pinatay niya para pakasalan kahit wala silang void. Okay, void. And collateral relatives, legitimate or illegitimate, up to 4th civil degree. So, bawal mo pakasalan yung mga pinsan mo. So, tingnan natin yung between stepchildren. Marriage between step siblings, Philippines. Okay, so pwede. At least clarify natin. Yung bawal is step parents and step children. Yun yung bawal. Pero pwede step siblings. Okay, add nga natin sa note yan. Okay. So, ayun na. Yung bawal, again, dalawang uri yan na bawal sa magkaka-relatives. Pag magkadugo kayo, ascendant-descendant, or magkakapatid, whether full blood or half-blood, incestuous. Void for being incestuous. Meron mang void by reason of public policy. Hindi sila magkadugo, pero bawal because public policy. Okay? Step-parents, step-children, parents-in-law, and children-in-law. So, pag children-in-law at children-in-law, di ba, kapag hindi naman kayo blood relatives, pwede. Adopting parent, adopting child, bawal. Surviving spouse of the adopting parent and adopted child. Surviving spouse of the adopted child and the adopter. An adopted child and the legitimate child of the adopter. Adopted children of the same adopter. Parties were one with the intention to marry the other killed the other person's spouse or his or her own spouse and collateral relatives, legitimate or illegitimate, up to the 4th civil degree. So, yung step siblings can marry each other. Lahat ng mga hindi na mention dito sa list na to, it's an exclusive list, pwede. Okay, next. Ground for void marriages. Mistaken identity. Siyempre, di naman yun yung pinakasalan mo eh. Subsequent marriages are void under Article 53, which is the non-recording in the proper civil registry and non-compliance with the requirements of law for partition, distribution, and delivery of presumptive legitimes to rightful heirs. Now let's go to Article 36, which is psychological incapacity of any of the parties. So psychological incapacity is a legal and not a medical concept. It is a personal condition which prevents a spouse to comply with fundamental marital obligations only in relation to a specific partner, existing at the time of the celebration of the marriage, manifesting either from the beginning or subsequently after. It is not strictly limited to mental conditions. It is neither a permanent or incurable condition. And clear and convincing evidence, however, must be shown. So ito yung mga ginagamit ng mga artista and powerful people to divorce, quote-unquote. Kasi walang divorce sa Pilipinas, so magpapa-annul sila. Psychological incapacity usually yung tirada kasi ito yung parang maraming pwedeng pasok. Diba? Yung thing about this, it doesn't attach to a person kasi it's not a medical concept. If na-declare yung marriage nyo na void because may psychological incapacity yung isa sa contracting parties, pwede pa siyang magpakasal ulit. Kasi hindi na-carry over na yung incapacity niya andun pa rin sa next. Pwedeng may capacity na siya to enter a new marriage. So, parang ganon. The burden of proof in proving psychological incapacity is on the plaintiff. The quantum of proof required in nullity cases is clear and convincing evidence. Psychological incapacity is neither a mental incapacity nor a personality disorder that must be proven through expert testimony. There must be proof, however, of the durable and enduring aspects of a person's personality called his personality structure, which manifests itself through clear acts of dysfunctionality that undermine the family. Okay. Incurable, not in the medical but in the legal sense. Incurable as to the partner. Okay? Parang hindi mo kayang gawin yung marital obligations mo with respect to your partner lang. Diba? Parang ganun siya. So, it's a good quote-unquote lusot na ginagamit nila. As to gravity, it must be shown that the incapacity is caused by a genuinely serious psychic cause. And, usually yung basis nila is yung previous decisions din that were similarly decided. Like, for example, pag yung facts and circumstances mo, same dun sa na-declare na null and void due to psychological incapacity. So, baka pwede mong i-invoke yan. Okay, so, yun. The decisions of the National Appellate Matrimonial Tribunal of the Catholic Church of the Philippines have a persuasive lang effect on nullity cases pending before secular courts. Persuasive lang. Okay. Magbasa na lang tayo ng kaso ng mga psychological incapacity kasi medyo broad yan eh. Basta, yun yung important thing about psychological incapacity. Meron kang incapacity to perform your marital obligations towards your partner. And it's a legal concept, not necessarily mental. And it must be serious. Okay. Annulment is the remedy if the marriage is voidable. Grounds are those provided for law alleged to have been violated. Judicial declaration of nullity of marriage is yung basis of Article 40 of the Family Code. The only acceptable proof of the nullity of the marriage. This may be obtained for any purpose, including but not limited to remarriage before subsequent marriage is contracted. This document must first be obtained. Failure to secure this document from the courts will render the subsequent marriage void. So, dati iba-iba yan eh. Merong time na hindi kailangan ng JDN. Merong time na kailangan ng JDN. Merong time naman na hindi kailangan. Meron naman kailangan. Basta yung, ayaan na natin yon. Basta yung point is, kasi merong mga old decisions na walang JDN, okay lang. Pwedeng mag-remarry. Meron naman na decisions na kailangan may JDN or else void yung subsequent marriage mo. Pero yung kailangan lang tandaan is yung ngayon, yung pinaka-recent jurisprudence is kailangan ng JDN bago ka makapag-contract ng valid subsequent marriage. And kailangan ng JDN para masabi mong void na yung previous marriage mo. This requirement of Article 40 has retroactive effect. There's no criminal liability for bigamy even if the crime was committed during the subsistence of a void ab initio marriage where a JDN was secured. Pero unless and until nabigyan ka na ng JDN or hanggang wala ka pang JDN, huwag ka munang magpakasal. Okay? Kailangan mong i-secure muna yung JDN mo. Pag may JDN ka na, then okay. The jurisdiction to annul is vested in the court of the nationality or domicile of the parties, not the place of celebration of marriage of the locus celebrationis. Subsequent marriage of spouses, where the requirements of recording under Article 52 of the Family Code has not been complied with, shall be null and void. The judgment of annulment or annulment of absolute nullity of marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitim shall be recorded in the appropriate civil registry and registries of property, otherwise the same shall not affect third persons. Articles 50, 51, and 52 of the Family Code in relation to Articles 102 and 129 of the Family Code rules governing the liquidation of the absolute community or the conjugal partnership of gains in the property regimes for valid okay, wait lang. The property regimes relate only to voidable marriage and exceptionally to void marriages under Article 40 of the Family Code. The declaration of nullity is a subsequent marriage contracted by a spouse of a prior void marriage before the latter is judicially declared void. Basically, yung kailangan natin malaman is merong requirements kasi na kapag may previous marriage ka, bago ka mag-validly enter into subsequent marriage, kung null naman talaga yon, is kailangan mong gawin yung responsibilities mo na liquidate mo muna yung properties mo doon, ibigay mo muna yung mga properties mo sa presumptive heirs mo, mga ganyan, i-distribute mo muna. Kasi, hindi naman pwedeng dalhin mo yan, tapos yung second marriage mo yung makikinabang. Paano naman yung mga anak mo dun sa first marriage? Ganun lang yon. Okay. So, tapusin natin hanggang legal separation. And then, yung property regime naman sa next video. Okay. Kaya natin yan. Naubos na yung laway ko. Voidable marriages. This marriage is valid until it is annulled. Therefore, it is terminable. There is a defect in the essential and or formal requisites of marriage. Defect, hindi. Kapag defect ng mali. Kapag defect kasi sa formal requisites of marriage, no effect. Diba? Kapag irregularity. So, essential. Mali yung notes ko dito. Ano ba yan? Okay. There is defect in essential requisites of marriage. Hindi formal. Essential lang. Pag may defect ulit yung formal requisites, no effect. Pag absence ng formal requisites, void. Pag absence ng essential requisites, void. Okay. The following grounds for avoidable marriage may be raised within a period of time as prescribed. Okay. So, ito yun. Lack of parental consent. So, a party that is 18 to 21 years of age must secure parental consent before marrying. Hindi sila bawal mag-marry. Okay? Merong legal capacity, 18 na eh. Pag below 18, syempre absence yun. Void yun. Ab initio. Hindi yun voidable. Pero kapag 18 na siya, 18 to 21, between those ages, kailangan ng parental consent. Kung wala kang parental consent, madidelay yung pag-issue sa'yo ng marriage license. Parang ganon. So, kung hindi na-obtain yung parental consent pero somehow, inalaw sila, diba? Valid yung marriage nila. Pero, pwede siyang ma-void. Voidable eh. Pwede siyang, for a certain time, pwedeng ipawalang visa kapag ka walang parental consent. Hindi siya absence, defect lang siya. So, voidable. Yung prescriptive period nito is 5 years from the time that the party reaches 21. So, ano to eh, yung logic nito is 18 to 21 ka, sure, pwede ka na upakasal. Pero baka naman masyadong bata ka pa, baka hindi mo alam yung pinapasok mo. Lalo't hindi mo kinonsult yung parents mo. Diba? Hindi nila alam. Baka naging padalos-dalos tayo dito, and marriage is a serious thing. So, pagdating mo ng 21, parang dinidim na ng law na, alam mo na yung pinasok mo. So, pwede ka pang mag-reset ng buhay mo na ayaw mo nang makasama yung taong yan. Kasi parang inisip mo, I was young then, I was stupid, this is a mistake. So, if you realize that, then, you can have the marriage terminated. Okay, de-declare siyang void. But, at the same time, if you reach 21 and then you still feel that you've made the right decision, then, ayun. Pero hindi siya unlimited. Meron lang siyang fixed time. So, 21, within 5 years from the time na 21, 22, 23, 24, 25, 26. So, pagka 27 mo, wala na, you're stuck sa marriage na yan. Kaya you have to decide within 5 years from the time that you turn 21. Okay? So, prescriptive period may also be filed not just by the party na 18 to na lacking parental consent at the time of the marriage. Can also be by his or her parent or guardian. Pero dito, before the party lacking parental consent reaches the age of 21. Okay, so 18 siya nagpakasal kunwari. Walang parental consent. So, si parent, pwede siyang mag-petition sa court na, voiding marriage na kasi hindi na-obtain yung parental consent namin. Pero yung time limit nila is until 21 lang. Okay? Pag yan, nag-21 na, okay, nasa kay party na yan. Kung gusto niya pang ituloy yung marriage na yan or na-realize niya na it was a bad decision or it was a stupid mistake he or she made because of, youth. Okay, next ground is unsound mind. It covers insanity, imbecility, or feeble-mindedness. So, there's a difference sa insanity and feeble-mindedness, which I think I already discussed sa CRIM. So, yeah. Ayun, iba naman yung insanity. Okay, mga insanity is parang lucid interval. Imbecility is parang you have the mind of 7-year-old or basta yung development ng brain mo medyo stunted. Hindi siya yung normal na hindi siya angkop sa edad. Parang na-stuck yung mental age mo sa certain age. Pero iba na yung age mo. Mas matanda na dapat yung pag-iisip mo. Hindi tugma. Feeble-mindedness naman, parang medyo may weakness lang sa mental prowess. Parang ganun. Confirm nga natin. Dapat particular tayo sa mga bagay-bagay. Okay, feeble-mindedness. Meron ako yan eh. Feeble. Okay. So, imbecile, one who, while advanced in age, has a mental development comparable to that of a child between 2 and 7 years of age. Feeble-mindedness, not imbecility. Okay. To be feeble-minded is to be mentally slow. But could still distinguish right from wrong. Medyo slow lang. Okay. People with an IQ below a certain number. Insanity naman is a complete deprivation of intelligence. Okay. So, moving on. Kapag unsound mind, so it covers insanity, imbecility, and feeble-mindedness. Yung prescriptive period if filed by the spouse who had no knowledge na insane pala yung partner niya or yung guardian ng insane before the death of any parties. So, in a way, wala rin siyang parang prescriptive period. Pero, parang wala rin eh. Kasi pag namatay siya, Yung insane, technically, widow ka na, you can remarry. But, again, syempre may legal effects yun, 'di ba? Kapag void or hindi. Kapag iba naman yung situation ng widow sa nagpaanal Kasi, pag void, wala talagang effects. Pag widow kasi, syempre may successional rights, ka pa. Anyway, fraud is another ground. Alam naman natin yung fraud. Prescriptive period filed by the innocent spouse. So, si innocent spouse yung may karapatan to file, not the guilty spouse, within 5 years from the time of the discovery of the fraud. Vitiated consent that was obtained through violence, force, intimidation, and or undue influence. Okay, kasama dito yung serious and irresistible force that was employed or compulsion because of an imminent fear to his or her person or family. Okay, pwede din, fraud includes, okay, to the exclusion of others, meaning exclusive list. Pag hindi pasok dito, hindi siya considered na fraud sa na quote-unquote na term na ginamit dito. Non-disclosure of conviction by final judgment of a crime involving moral turpitude. Concealment of the fact of pregnancy at the time of the celebration of marriage. Concealment of the fact of sexually transmissible disease regardless of its nature at the time of the marriage. And concealment of drug addiction, habitual alcoholism, and homosexuality. So, dapat may concealment or may non-disclosure mga ganito. Hindi kasama yung niloko ako, sabi niya sa akin, bilyonaryo siya. Yun pala, nung kasal na kami, nalaman ko he broke. Diba? Parang gano'n. Hindi siya kasama, hindi siya considered fraud. Prescriptive period filed by the innocent spouse is within 5 years from the time of the cessation of the cause of vitiation or fraud, discovery of the fraud. Next ground is impotency or physical inability to consummate the marriage. This does not mean sterility or infertility. Hindi to, pagbaog ka, hindi siya ground, no, to terminate the marriage. Hindi voidable yung marriage mo kapag may isa sa inyo baog dyan. Or hindi kayang mag-conceive. Or mababa masyado yung sperm count. Hindi ganon. Yung ibig sabihin ng impotency is pag may erectile dysfunction ka, if you cannot have sex, basically that's that. If there's an issue wherein you cannot consummate the marriage and have sexual intercourse, you're just incapable of doing so. Okay, serious and incurable sexually transmissible disease is also a ground. So, yung isa dito, yung concealment of the fact of STD, kahit hindi serious, kahit hindi incurable, kahit curable pa yan, basta may concealment of that fact. Tinago niyang may STD siya, pero yung STD niya, ano lang naman, parang tulo lang naman na pwede namang i-cure or something na kayang i-cure ng over-the-counter drugs or alam mo yun, something very simple. Still, it's an STD. Regardless of its nature, if there's concealment thereof, then pwedeng voidable. Pero pagka serious and incurable, kahit walang concealment, basta meron lang siyang serious and incurable STD. Yun. For example, unfortunately, pag may AIDS, diba? So, may prescriptive period pa rin though, within 5 years from the date of the celebration of the marriage. Kasi by that time, alam mo na rin naman siguro. Okay, next, legal separation. Separation of bed and board of the spouses without dissolution of marital bond, without the entitlement to remarry. Bakit ka bawal mag-remarry? Kasal pa rin kayo Ayaw niyo lang magsama Diba? So, inaalaw to kasi baka you can't stand each other na talaga. Tapos, possibly wala kayong grounds for a void marriage or for avoidable marriage. Diba? But you just can't stand each other. So, ito yung mga grounds. Repeated physical violence or grossly abusive conduct against the spouse or the child of your spouse. Hindi kailang common child. Kung meron siyang anak, diba? Sa iba. Yung asawa mo. Pag yun yung inaabuso mo, ground yun sa legal separation. Attempt to corrupt or induce the spouse or the latter's child to engage in prostitution. physical violence against the spouse to compel the latter to change religious or political affiliation. Again, if you enter into a marriage, you still retain your individuality. You have the right to practice your profession or not. You have the right to your religion, to choose your religion. You have the right to choose who to vote, di ba? Ganon. So, walang pilitan. Pero, dapat may physical violence. Kung parang dinadaldalan ka lang naman na, bakit si ganito yung binoto mo? Dapat ganito, alam mo ba yung presidente mo, ganito, ganyan, tapos gaaway ka palagi. Kung hindi naman siya constituting as physical violence, it's not the ground. Dapat may physical violence, and yung purpose ng physical violence para pilitin ka to change your religion or to change your political affiliation. So, physical violence. Final judgment of conviction of a crime with an imposable penalty of more than 6 years. Drug addiction or habitual alcoholism after the celebration of the marriage. Yung concealment kasi nito can be a ground for voidable eh. Lesbianism or homosexuality. Legal separation lang siya. Hindi siya voidable. Yung concealment nito, okay, concealment of such pre-existing condition or inclination before and during the celebration of marriage, ito yung magiging voidable. Pero kapag ka-straight naman, kunwari, yung partner mo, nung nag-celebrate kayo ng marriage, tapos naging homosexual lang siya later, like after 10 years. Okay? Hindi siya voidable. Pero, pwede siyang legal separation. Yung just the fact of it. Diba? You're not forced to endure the pain of having a partner who no longer appreciates you and can only be satisfied by someone else, and that you no longer have the capacity or the faculties to satisfy your partner kasi iba na yung inaano niya, diba? So, balik kayong separate. Okay. Pag concealment, dapat existing na siya at the time of the marriage or before. Hindi mo lang alam na yung reason dyan bakit siya voidable is, kung alam mo lang sana, diba, hindi ka sana nagpakasal. Okay, next ground is contracting of subsequent bigamous marriage. Without prejudice to the right of the innocent party to file a criminal action against the guilty parties. So, kapag ka eto, sa bigamos, i-clear ko lang. Di ba yung bigamos, void marriage? Yung bigamos marriage, yun yung void. Di ba meron kang first marriage, tapos meron kang second marriage? Yung bigamos marriage mo, void siya. Right? So, wala na to. Ikaw naman, natira ka pa, valid ka pa. Kahit na si husband mo nag-commit ng bigamy, pwede kang mag-legal separation if talagang hindi mo siya mapatawad. Pa. Pwede ka lang mag-file ng criminal action. Nasa sa'yo yun. So, yun. Attempt on the life of the spouse. Siyempre, gusto ko nang patayan. Magsistay ka pa ba dyan? Nakakatakot yun. Sexual infidelity. Mere sexual infidelity suffices. There's no need to meet the requirements of adultery or concubinage. Nalaman mo nakipag-sex sa iba, pwede na kayo mag-separate. Abandonment. Abandonment is the unjustifiable absence of the guilty party from the conjugal home without the intention of returning except if there is condonation, consent, connivance, in pari delicto, dalawa kayo may mali, di ba? Pag in pari, yung phrase is, yung hands, dapat don't come to court with dirty hands or something, or clean hands. So, basta dalawa kayo may mali, okay? Bawal kang magreklamo kung ikaw may mali ka rin, di ba? So, kunwari, inabandon ka, pero ikaw nang abandon ka rin, di ba? Condonation is the tolerance or forgiveness of the marital offense after the act. Okay? Nalaman mo, sige na lang, finorgive mo na. Consent is bago. Okay, sige, makipag-sex ka dun sa iba. Nagbigay ka ng permission. Connivance, parehas kayo. Okay? Parehas kayo act together to commit a marital offense. Collusion, nagplano kayo paano ma-dissolve yung marriage nyo. Mag-fake kayo dyan ng grounds or something. In pare delicto, parehas kayong may kasalanan. So, yun yung bawal yun. Cooling off period. The case of legal separation may only be heard by the court 6 months after its filing. Para mabigyan pa kayo ng time to reconcile. So, yun. Exception is, the court will immediately hear the case, of course, immediately after filing if the ground involves violence. Okay? Repeated physical violence. Such court will also issue the necessary temporary protection orders ex parte. And permanent protection orders may be issued after notice and hearing. So, si prosecutor required you to verify that there is no collusion or kailangan i-prevent ni prosecutor yung collusion. There should be no fabrication or suppression of evidence. So, walang collusion, dapat mag-file annulment. Okay? Para ma-render yung marriage void. Okay? Sa psychological incapacity, gawa niya lang ba yan? May collusion ba dyan? Mga ganyan. Or pag voidable, ganun din. Or sa legal separation, ganun din. A decree of legal separation may only be granted upon court hearing wherein evidence is presented by the parties. Mere admission of the parties of marital offenses will not be sufficient. The effects of legal separation will only ensue upon the award of the decree of legal separation. The marriage bonds will remain and there is no entitlement to remarry, but the property regime is dissolved and liquidated and entitlement to support ceases. However, the guilty spouse may still be compelled to support the innocent spouse. Pero dapat may court order. Donations by reason of marriage will remain valid except if the donee is the one in bad faith and these donations are revoked by operation of law, and the innocent spouse may revoke in insurance policy the status of the guilty spouse as the former's beneficiary, and the guilty spouse is disqualified to inherit from the innocent spouse intestate succession, and custody of the children is given as a general rule to the innocent spouse without prejudice to the preference given to the mother by virtue of the maternal preference rule. Reconciliation after filing of legal separation, what happens? So, if during the pendency of the proceedings, the spouse is reconciled, mataterminate yung proceedings. Bakit ba itutuloy? If the decree of legal separation has been issued already, such decree shall be set aside, and any separation of property and forfeiture of shares of the spouse remains, unless yung spouse agrees to revive their former property regime. If one of the parties died during the pendency of legal separation, the proceeding will be dismissed. Malamang. The heirs cannot continue the suit, and the effects of legal separation cannot hold. Succession and entitlements will follow as if there was no legal separation filed at all. Okay, so that's it for marriage. Okay, there are a lot of jurisprudence na fun sa marriage, but I will no longer discuss. Ayun, marami naman yan. Basta marriage, maraming kaso involving marriage. So, yun. And marami na rin parang previous bar questions involving marriage. Marami rin tayong mga naging exam sa law school involving marriage. Kasi sa law school, di ba, persons and family relations, pag first year ka, yung marriage parang up to midterms mo yung na-coverage eh. Tapos isa-isa dyan yung voidable legal separation. So, maraming pwedeng questions na balikan. Ayan. Okay, so, bye. See you sa property regime video.